Chancellor, Vice-Chancellor, distinguished guests, members of the judiciary and the legal profession, members of the University of Adelaide community, ladies and gentlemen, good evening and welcome to this 7th lecture in the James Crawford Oration series on international law. My name is Melissa de Zwart and I am the Dean of Law, and it is my privilege to welcome you all here. We are meeting on the traditional lands of the Kaurna people, on which the 3 campuses of the University of Adelaide are built. And in acknowledging that traditional ownership, we pay our respects to the Kaurna people and their elders, and we also recognise their ongoing connection to this land and its spiritual and cultural significance to them. The James Crawford Oration series on international law was inaugurated in 2003 to honour Professor James Crawford, who is, as I'm sure that everybody in this room knows, the eminent Australian international lawyer and judge of the International Court of Justice, and because of his beyond compare contributions to the field of international law. We're very proud to say that Professor Crawford is an alumnus of the Adelaide Law School. He graduated with LLB honours in 1971, and after completing his doctoral studies at Oxford, he returned to Adelaide in 1974 to be appointed to the academic staff as lecturer, then senior lecturer in 1977, reader in 1982, and held a personal chair from 1983 to 1986, and from then on he went to a chair at the Sydney Law School. He was during this time appointed to the Australian Law Reform Commission in 1982, and his report on the recognition of Aboriginal customary laws remains a groundbreaking study and important work in that area. Professor Crawford then went on to become the Whewell Professor of International Law and Director of the Lauterpacht Centre for International Law at Cambridge University. In 1992, he was also elected to the International Law Commission. He served as a Special Rapporteur on State Responsibility from 1997 to 2001, and was also responsible for the International Law Commission's draft statute for an international criminal court. As well as all of this academic work, he appeared in more than 40 cases before the International Court of Justice, and in his spare time developed a substantial practice as an international arbitrator. And of course, to the immense national pride of Australia, in 2014 he was elected Judge of the International Court of Justice, and has, I think, quite accurately been described as the most eminent international lawyer Australia has produced. The Crawford family have always provided their very strong support to this lecture series, and we are delighted that Michael and Caroline Crawford are able to join us here this evening. I would now like to invite our Interim Vice-Chancellor and President, Professor Mike Brooks, to introduce our guest speaker this evening.
Thank you so much, Melissa. Chancellor Kevin Scarce, Commodore Vicky McConaughey, Michael and Caroline Crawford, distinguished guests all. It's my great pleasure to introduce this evening our guest speaker for this prestigious lecture, as we've heard, the 2017 James Crawford Oration on International Law. Tonight's lecture, as you see, is entitled The Grey Zones in the International Law of Cyberspace, and we could not be in for a more topical subject, with claims and counterclaims around the US election and Russian hacking and so forth. It's reflective, I think, of a new type of warfare that is now becoming mainstream. We're privileged tonight to hear from one of the foremost experts in international law in this field. Professor Michael Schmitt is the Charles H. Stockton Professor and Chairman of the Stockton Center at the United States Naval War College. He is also the Francis Lieber Distinguished Scholar with the Lieber Institute at West Point, Professor of Public International Law at the University of Exeter in the UK, Fellow at Harvard Law School's Program in International Law and Armed Conflict, and Senior Fellow at the NATO Cyber Defence Centre of Excellence. Professor Schmitt has been Editor-in-Chief of the Tallinn Manual, a study of how international law applies to cyber conflicts and cyber warfare. The Tallinn Manual is an invaluable tool in understanding the legal rights and obligations in this field. Such manuals have great significance, and it is wonderful that Professor Schmitt is also working as an editor on the Manual of International Law applicable to military uses of outer space, which the University of Adelaide's Research Unit of Military Law and Ethics is working on with the Universities of McGill in Canada and Exeter in the UK. No doubt his expertise will be of tremendous benefit on that project. Professor Schmitt served 20 years in the United States Air Force as a judge advocate specializing in operation and international law. Before that, he graduated first in class from the Naval War College. He's obviously wonderfully qualified to help make sense of warfare in cyberspace and the application of international law in this field. Please join me with great pleasure in welcoming Professor Michael Schmitt to present the 2017 James Crawford Oration.
I hate to correct the Vice Chancellor, but that comment about the Russians meddling in our elections, fake news, okay? It's fake news. So thank you all for coming. What I've been asked to talk about tonight is cyber, because I've been working for the past 7 years on a project called the Tallinn Manual project. And in the course of that project, we identified something called gray zones in international law. So that's going to be my topic tonight. But if we're going to do this, we have to start at the beginning. And the law related to cyber, the international law related to cyber, began in Newport, Rhode Island at the Naval War College. A long time ago, for the youngsters in the audience, it was in the last century. I was an officer attending the Naval War College, an Air Force officer, an exchange officer at the Naval War College. And I was struck by the fact that everyone wanted to talk about what was then called computer network attack, today called cyber operations. And the war fighters, the operators, the commanders in the class were waxing eloquent about all the things that they could do with this new form of warfare, this computer network attack. And I remember in particular one officer telling my seminar that, God, with this computer network attack, you know what we can do? We can open the doors of a dam and let the water rush downstream and therefore deny the enemy the use of that territory. Well, as a lawyer, that made me a little bit nervous, because if you do that, you're going to destroy a lot of civilian property and you're going to place a lot of civilians at risk. And therefore, there are rules of international humanitarian law that govern that operation, but the war fighters, the operators, were completely ignorant of those rules. And so I stayed on the faculty after I graduated, and we've launched a project to look at cyber operations and how international law, in particular international humanitarian law, limited cyber operations. So we held the first conference ever on cyber. We did a book, because you always got to do a book when you have a conference. Every academic knows that. We did a book, and then 9/11 happened. And when 9/11 happened, all of us who were involved in military affairs, Dale, myself, others, we all shifted focus. Cyber had caught our attention, but now we were focused on terrorism. We were focused on issues like, do transnational terrorists, when they attack you, do they launch an armed conflict to which law applies? How do you treat detainees? Can you put detainees in black sites in Poland? Can you torture them or not? What is torture? And then we looked at the wars in Afghanistan and Iraq. So cyber was big in the 1990s, and by 9/11, cyber was completely forgotten. It was completely forgotten until April of 2007. And in April of 2007, something happened that caused us all to refocus our attention on computer network attack, which by then was known as cyber. It's a very interesting story. Estonia was, in the early part of the 20th century, gained its independence, became an independent country in 1923. However, in World War II, Estonia was simply a ground over which warring forces crossed. So it was occupied by the Germans for a while. Then the Soviets came and occupied, and the Soviets won the war, as you may have heard. And when they won that war, what they did is they annexed Estonia. And Estonia became a Soviet republic. It lost its independence. And that existed, or that took place for about 50 years, until it regained its independence when the Soviet Union broke up, when the Soviet Union collapsed. Well, in every Soviet city, there was a statue to the Great Patriotic War. And in Tallinn, which was the capital of Estonia, there was one such statue. It was made of bronze. It's a very impressive statue. Socialist realism showing a Soviet soldier who had just defeated the Germans. And as in every city in the Soviet Union, it was smack dab in the middle of the city. Well, to the Estonians, it wasn't the Great Patriotic War. To the Estonians, that statue represented the occupation of their nation for half a century. So they decided to move the statue. And they were going to move it to, they did in fact move it, to a Soviet war cemetery on the outskirts of town. The problem is Estonia is a wonderful country. It was the richest republic in the Soviet Union. So in that 50-year period, lots and lots of ethnic Russians moved to Estonia. And by 2007, the population consisted of 23% ethnic Russians. And to them, it really was the Great Patriotic War. And so moving this statue was extraordinarily offensive to the ethnic Russians of Estonia. And so they took to the streets. They rioted in the streets. And as the riots were going on, cyber attacks started against Estonia. They were against both public and private enterprise. The president, the prime minister's websites went down. The Ministry of Defense could not function. Banks could not function, on and on and on. It really shut the country down. Now, Estonia by then had become a NATO state. So the Estonians said, isn't this great? Because all we have to do is look to our NATO allies and they'll come to our defense against the evil Russians, who they hate. But of course, the Americans and the Brits and the other members of NATO were rather preoccupied at the time with operations in both Afghanistan and Iraq. Now, eventually what happened is the cyber attacks, which were conducted from 177 different countries, mostly Russia, they died away. It took about 10 days and the cyber attacks stopped. But this was a wake-up call, because it begged the question of whether or not cyber attacks could cause, for example, a war between the West and Russia. So people started thinking cyber again. The problem was no one had considered the issue before 2007. So we really didn't know what the law was. And then the very next year, something else happened. There was a war between Russia and Georgia. And during that war, there were again massive cyber attacks from Russia against Georgia. So whereas in the Estonian case, we saw cyber attacks occur during peacetime, now we were watching cyber attacks occurring in the midst of an armed conflict. And again, the international community was left scratching his head, wondering what law applies. When the Russians attack a Georgian bank, is that an attack on a civilian object prohibited by international humanitarian law or not? No one knew the answers. So after the Estonian attacks and after the Georgia incident, NATO decided to create a center of excellence on cyber issues. And they established it where else but in Tallinn. This center, called the NATO CCD, Cooperative Cyber Defense, COE, Center of Excellence, decided to start looking at the law. And what they did was they commissioned a study by 20 experts, most of whom were academics with some practical background in government, serving as a government legal advisor. They commissioned a study to look at how cyber was limited by humanitarian law during an armed conflict, and when cyber operations might violate the prohibition on the use of force found in the UN Charter and allow a state that had been attacked to resort to force in self-defense, either force by cyber means or kinetic force. And they asked me to be the director of this project. So we spent about 3 years, and we created, trying to answer this question, what is the law and what are the legal responses available to states? We spent 3 years looking at this, and that resulted in the Blue Book. The Blue Book was the first Tallinn Manual. It was limited to war and big issues of the use of force. It went pretty well, and so at the end of it, you know, if you're having something good, ask for some more. So the NATO Center of Excellence said to me, what would you like to do next? And I said, well, I suspect we ought to probably keep going. We talked about war. Let's do peace now. Let's look at issues like space law. Let's look at the law of the sea. Let's look at human rights. And let's look at state responsibility, particularly appropriate in this audience, because, of course, James Crawford is the father of state responsibility, and we relied upon his work very, very heavily in producing Tallinn 2.0, a clever title which I came up with, okay? We argued and argued and argued, but how clever can you get? At any rate, we produced the Green Book. We finished it in February of this year. We launched it around the world. We launched it here in Australia, at Canberra. We also launched it in Washington and Tallinn and The Hague and so forth. Now that manual addresses the law that governs both peacetime and wartime. And it's a big thing. It's over 500 pages. It's got 154 rules with extensive legal commentary on all the rules. You'll see why that's important in a moment. It was done by an international group of experts that was different than the one that had considered warfare, because we needed greater variety, and we had been criticized for not being inclusive enough in our first effort. So this time, my job as director, and Dale is the director of the Space Law Project, he knows how this works. You desperately search for people all over the world to join your team. We had someone from China, someone from Nigeria, of course Americans, Canadians, Australians. Tim McCormick from Melbourne was on our team. We even had a Russian. Although it was kind of an unusual situation with the Russian. Everyone knew we needed a Russian, so we found a Russian. Wonderful scholar at the Diplomatic Academy in Moscow. And the day before the first meeting, we got an email, myself and Liis Vihul, who was the manager of the project, a brilliant Estonian attorney. We get this email from this scholar that says, I can't come. And that was probably because the Diplomatic Academy is tied to the Russian government. They don't want her to participate. So I'm scratching my head going, where in the hell am I going to find myself a Russian on a weekend? I knew there were plenty of Russians, but the last time you met Russians in Estonia, they were rioting, so we weren't going to take one of them. So I thought and thought and thought, and I remembered that I had met the dean of Minsk University in Belarus, okay? Now, if you're a kid from South Texas, there ain't a lot of difference between a Russian and a Belarusian. It has sort of the same sound to it, so if I could get one of those, I could check the Russian block. And so I called this guy, Andre, who comes from a country that's about as dictatorial as it can get, and is run by a crazy person called Lukashenko. I called him up and said, Andre, can you come to Tallinn to join the Tallinn Manual group, thinking this is the stupidest question ever. If you need, we can contact the embassy. Well, I knew it was not going to happen. Oh, Mike, my friend, I will come. Turned out he was in Pisa on vacation with his family. He dumped his family, hopped on an airplane, flew to Tallinn without telling the government of Belarus that he was coming, and joined our project, so we had a Russian too. Anyways, it was a very international group, which is important. In addition to the experts we had, 19 of them, we had 50 peer reviewers scattered around the world that were looking at aspects of the project. And additionally, the Dutch government approached us and asked, how can we help? And what we asked them was, can you bring states into the process? So what the Dutch Ministry of Foreign Affairs did is they went out to states around the world through their embassies, and they said, listen, These guys are writing this manual on cyber. You've heard about Tallinn 1. This is Tallinn 2. Can you send representatives? 50 countries and international organizations like the Organization of American States sent representatives on 3 occasions to The Hague, where we presented drafts and allowed them to comment on those drafts as the process was going on. Why is all this important? It's important because states and the involvement of states and the involvement of the international community and the involvement of so many peer reviewers meant we went from having no cyber law to having a big, thick book full of cyber law. So there was lots of cyber law. States liked it. These are comments from the President of Estonia and the Minister of Foreign Affairs, and there were many other similar comments from the legal advisor at the State Department, all saying this was a useful tool for states in understanding how to apply international law in the cyber context. Now, it wasn't just academics who were involved in this process. This was an unofficial effort. States were at the same time involved in the search to try and figure out how international law applied to cyberspace. And they did so through the United Nations. What happened, because states and only states make international law, what happened was the General Assembly convened something called the Group of Governmental Experts. There's a long title, it's up there on the slide, but on cyber. States seconded people to this group, and the mission of this group was to identify norms for cyberspace, both binding legal norms and hortatory norms. In other words, you should do this. Not you must, but you should do this. There were 5 such groups. The most recent was in 2016. Now, those groups sometimes produced reports, and the reports were very important. There was the report in 2013. The most recent report was in 2015. And here, and this is the important point, whereas we had a bunch of academics that had identified a bunch of law, now we have states identifying a bunch of law. So, for example, jurisdiction applies in cyberspace. So Australia has jurisdiction over you when you get on your iPhone. That was new in 2015, the acknowledgement of jurisdiction. They confirmed that states had sovereignty over everything on their territory and all the cyber activities that occur on their territory. That states are equal in cyberspace. Every state, whether it's Estonia or China, every state has the same duties and the same obligations under international law. And states are not permitted to intervene in the internal affairs of other countries, the internal or external affairs of other countries. Acknowledged human rights. This was very, very important. There were lots of questions about, do human rights apply to your cyber activities? Here, this group of states in the UN said not only do states have an obligation to individuals to respect their human rights, but states have an obligation to protect your human rights against interference by others, particularly other states. It also confirmed that the measures that are set forth in the United Nations Charter applied in cyberspace. Now, this was very important because one of the provisions in the UN Charter is Article 51. Article 51, as many of you know, is the self-defense provision. So what the GGE was doing was saying that with respect to cyber operations that a state is facing, that state has the right to defend itself in cyberspace or outside of cyberspace in the event those hostile cyber operations are very severe. Also, although it did not mention international humanitarian law, the law that applies during an armed conflict, it did note the principles of humanitarian law: humanity, necessity, proportionality, distinction. In other words, what the GGE was saying is law applies to cyber operations conducted during an armed conflict. They confirmed, the GGE members confirmed, that states may not turn to non-state actors, hacktivists, hacker groups, political hacktivists. States may not turn to non-state actors to engage in activities that would be unlawful for the state itself. And if a state did that, it would be the state that was responsible for the actions of the non-state actors. And finally, it confirmed, the GGE confirmed, that states have a duty that lawyers call due diligence. States have a duty to ensure their territory is not used as a base of hostile operations against other countries. That if such hostile operations were underway, and those hostile operations would cause, the standard is, serious adverse consequences, then that state, the state where those things were taking place, has a legal responsibility to make them knock it off. This was all very important. By 2015, with the Tallinn Manual underway and with this report, we knew that international law applied, and it applied a lot to cyber operations. So things were going along pretty well. And it wouldn't be a good story if there wasn't a crisis, and we got a crisis now. I mentioned that there were 5 groups of governmental experts. The last one was convened by the General Assembly in 2016. And that one collapsed. It collapsed this June, June 23rd. And it collapsed because of opposition by Russia, China, Cuba, and a number of other states to certain basic principles of international law and the application of those principles to cyber operations. These states objected to the concept, to the premise that states have a right to respond to unlawful acts conducted against them in cyberspace. These are called countermeasures. It's important that you understand what a countermeasure is. A countermeasure is an action by a state that would be unlawful except for the fact that it's in response to another state's unlawful action and designed to make the other state stop, to return to lawfulness. Because State A conducts unlawful cyber operations against State B, perhaps destructive cyber operations against some of my government's cyber infrastructure. I now have the right to do something that I otherwise could not do, like hack back into State A's government infrastructure to impose cost on State A to make State A stop. China, Russia, Cuba, the other countries were unwilling to acknowledge this very basic premise of international law. Even more surprising, those states were unwilling to acknowledge the right of self-defense in cyberspace. There was going to be a simple statement that said the law of self-defense found in the UN Charter applies to cyber operations that are egregious enough, known as an armed attack. If you have an armed attack through cyberspace, which would be something which is pretty destructive, then a state should have a right to respond to that armed attack forcefully. But this time, despite the fact that in the 2015 report, they had acknowledged that the UN Charter applied, and this right is found in the UN Charter, this time they were unwilling to acknowledge this. And then, very confusedly again, these states were unwilling to acknowledge, expressly acknowledge, that international humanitarian law applied during an armed conflict with respect to cyber operations. This was also confusing because if you've been listening, you will remember that in 2015, the principles of humanitarian law had been agreed to by these same states. Humanity, necessity, proportionality, and so forth. But by 2016 or 2017, June of 2017, suddenly these states are unwilling to agree. So this represents a real crisis. We had made a great deal of progress in trying to understand how international law applied to cyberspace, yet for some reason, not everyone, certain states are backing away from that premise. Now, it's not just the bad guy states. This is, you may have heard of this country, it's the United States, okay? I don't recognize it much anymore, but it is the United States. Interestingly, on the day before the inauguration of Donald Trump, the General Counsel at the Department of Defense issued a memo. The memo was addressed to the Judge Advocate Generals of all the services, in other words, the senior lawyer in the Air Force, senior lawyer in the Navy, and so forth, as well as the senior lawyers at what we call combatant commands, like United States Central Command, United States European Command, United States Pacific Command, and it was a memo on sovereignty, and it circulated widely. At the time I was in Estonia. I got a copy from an Estonian who got it from someone from Denmark. And I read the memo and I said, this is a very strange memo. I'm an academic. I'm going to write me one of those article things on this memo. Word got back to the Department of Defense, and I got a phone call that said that memo has now been made for internal use only, thereby preventing me from writing said article or explaining to you what the memo contains. But we do have some hints as to what it contains, because the staff judge advocate at United States Cyber Command, a wonderful attorney and a great guy, is in the process, is about to publish an article about sovereignty in cyberspace, along with another former senior attorney in the Department of Defense. And the article says, I've read it because I've also written a response, it's going to be published in the American Journal of International Law. It says, sovereignty is not a primary rule of international law. Now, I know that's legal mumbo-jumbo for the non-lawyers, but what it means is if I conduct a cyber operation into another country, a remote cyber operation into another country, the other country may not claim that its sovereignty has been violated, because sovereignty is a broad general principle from which other rules emanate, but it's not a rule in itself. This is very, very confusing to many of us, because we have a whole chapter on sovereignty in the Tallinn Manual, and anything that is in conflict with Tallinn Manual is wrong. That's right. So we got a whole chapter on this sovereignty, and the UNGGE had confirmed sovereignty on 2 different occasions. So this is very strange, what's happening. What's happening now is some organizations within states and some states seem to be backing away from the application of what most of us would find to be basic legal principles. Now, why? Well, I can only guess. My guess is that it's all about ambiguity in international law. You see, when international law is clear, it presents some problems. The first thing is, if you have clear rules, that limits your options. If sovereignty applies in cyberspace, lots of offensive cyber operations that you might want to conduct against another state are off the table. If international humanitarian law applies in cyberspace and you want to conduct cyber operations against civilian infrastructure in the enemy territory, those options are off the table. You can't do that. That's a war crime. So rules limit what states may do. Moreover, clarity opens the door to condemnation, universal condemnation. If we know what the rules are, when a state crosses the line, it's easy to get consensus on condemning that state and taking action against that state, like imposing sanctions. And finally, international law provides for remedies for the violations of international law against you. We mentioned countermeasures. If the notion of countermeasures is clear when this state conducts a cyber operation against me and it violates international law, if the notion of countermeasures is clear in international law, now I can respond. And the same is true with self-defense. If this state conducts cyber operations against me that are severe enough to constitute an armed attack, now I can respond forcefully. So clarity in remedies can limit what states do. And so certain states and certain organizations and certain pundits are trying to create and preserve and exploit what are gray zones of international law. In other words, gray zone of international law is where you don't know exactly for sure what the law is. It's gray. Maybe this, maybe that. It's a little bit unsettled. So gray zones are being used by states in order to conduct operations. Some states create gray zones. So we see this discussion over sovereignty. What they're trying to do is create grayness where we thought it was black and white. Most senior legal scholars thought, yeah, sovereignty applies in cyberspace. Of course it does. But now we have a state, not a state. We have an entity within a state, and let me assure you there's a lot of debate about this within and outside of government in my country. But we have an entity that seems to suggest that sovereignty doesn't apply. It's creating a gray zone. Only the village idiot would suggest that IHL does not apply to cyber operations during an armed conflict. But now we have some states claiming that it does not, creating gray zone. They may preserve gray zone. So when the states back away in the GGE from these statements, what they're trying to do is make sure that clarity doesn't emerge from this process. And then states exploit the gray zone in a big way. The classic example are the operations against Estonia that I mentioned in 2007, because it raised all sorts of questions, questions that reside in the gray area. These operations were conducted by non-state actors, okay, individual hacktivists and groups that have some kind of shadowy tie to the government in Russia and so forth. So the Russians were exploiting the fact that it's unclear when you attribute the actions of non-state actors to a state. It gave them room for maneuver. Additionally, it raises the question of whether, even if they weren't responsible for the operations under the law of state responsibility, didn't they have an obligation to make the hacktivists stop, to do the best they could, to do everything feasible to make those operations? Well, that's kind of a gray zone due diligence. And so the Russians were operating within the gray zone. Were these operations a use of force? Did these operations implicate the law of self-defense? Again, gray zone questions. So the Russians in 2007 are operating in the gray zone because they know that it's hard to pin the rose on them. And then we have the hacks that the Vice Chancellor mentioned, the fake news hacks, that the Vice Chancellor mentioned against the Democratic National Committee and other activities to interfere with elections. Those operations raised questions of sovereignty. But you see, sovereignty is right now a little bit gray. So the Russians were operating in that zone of sovereignty, in that zone of grayness, because they knew that it would be hard to get condemnation of them, to get consensus condemnation of them. They knew that it would be difficult for the United States to come to the conclusion that there had been a violation of international law by virtue of these operations, such that the United States could, for example, conduct hackbacks against Russia. Ditto with regard to intervention. It's a very gray area of international law. I happen to believe the Russian operations violated the prohibition on intervention in our internal affairs, the internal affairs being elections. But another person, the Estonian manager of our project, Liis Vihol, doesn't think so. She doesn't think it's intervention because it really was simply releasing emails that were truthful. So you see there's this gray area that allowed the Russians to operate without suffering the consequences of those operations. So what we're seeing here is asymmetrical warfare. So we have two sides to this battle. We got the good guys and we got the bad guys. So the good guys are committed to the rule of international law. And what that means is because the law is gray, because they're preserving these gray areas, the good guys will call the country Australia. Australia will hesitate to conduct certain cyber operations out of concern in these gray areas that it might, for example, an operation might, for example, violate sovereignty, that the operation might violate the human rights of individuals who are on the other side of the operation, that the operation might constitute a use of force. So the good guys, the law-abiding states, the ones that believe in the rule of international law, are going to hesitate. And for those who work in government, you know what the answer is going to be. The answer is going to be, don't conduct the operation. We don't want to risk violating international law. Moreover, those countries will hesitate to engage in robust responses in the face of hostile operations against them because the law surrounding the legality of those responses is somewhat gray. So good guys are going to say, wow, I really want to hack back. I really do. But I'm not absolutely certain that it's lawful to do so. We think it's lawful, but we're not absolutely certain, and we risk some states saying we operated unlawfully. So in the DNC hacks, what was the U.S. response? It was to throw some Russians out of the United States, to impose some sanctions on individual Russians. Well, you can do that because the Russians violated international law, or for no reason at all. Or for no reason at all. If you want to get rid of Russian diplomats tomorrow, you just send them home. You just send them home. It's not a violation of international law. But did we hack back? No. Did we think about it? I suspect we did think about it. But I bet some lawyer said, well, I'm not quite certain that there was a violation of international law that would enable us to engage in countermeasures, and we're not absolutely certain that the law of countermeasures is clear. So we hesitated. Meanwhile, bad guys see this as opportunity, right? Because it's gray area. And so they operate in these gray zones, and they don't risk universal condemnation. Because within countries, there's going to be arguments, just like the DNC hack, there's going to be arguments over, did they violate international law, or were they just being nasty? And can we respond is the other thing. The target states are going to hesitate to respond. So these gray areas represent extraordinary opportunity for states that are not committed to the rule of international law. Now that's asymmetrical warfare. That's asymmetrical warfare. One state operates according to one set of rules, another state operates against another state of rules. The countries that don't abide by the rule of law are not committed to the rule of law. They have a unique advantage in this environment. Now, for those who are old enough, like Dale, for those who are old enough, you will remember what happened after 9/11. After 9/11, we have massive attacks, significant attacks against the United States. What was the U.S. reaction? The U.S. reaction was to take off the legal gloves. Remember, there was an argument about whether or not the Geneva Conventions applied to our operations in Afghanistan. Are you kidding me? There was a real sense that if the bad guys are going to operate in violation of international law, that's just not fair, and we shouldn't have to abide by international law either, because then it's not a fair fight. And so I have some concern that the same thing is happening in the cyber environment. We have bad guys operating in the gray zones where the law is unclear, and we have good guys talking about in-kind operating in the gray zone for their advantage. So, what are the gray zones that I see? There are lots and lots of gray zones. The Tallinn Manual, unfortunately, turns out to be a playbook for the bad guys who want to operate in the gray zones, because we were very cautious. We did not want to assert that something was the law if we were not certain. So although there are 154 rules and 600 pages of commentary, over and over again we said, yeah, we agree that this is the rule, but the interpretation of the rule is subject to disagreement. We acknowledge that. Over and over we say the majority of the experts said this, the minority interpreted it like that. And sometimes, even when we were in accord, we acknowledged that some states might not agree with us. So we identified the gray zones in the manual, which means if you're sitting in one of these countries not committed to the rule of law, all you got to do is buy yourself a copy of the Tallinn Manual, flip through and start finding the places where we disagreed or we could not achieve consensus. And that represents the gray zone. Perhaps the most important gray zone is sovereignty. Now, I've mentioned that there is this approach that says sovereignty is not a rule. It's a broad principle that doesn't, it's not a red line that you cross. Now, that's wrong, okay? And it's wrong because we all acknowledge here that states have territory and that territory is inviolable. And so if you conduct cyber operations into another territory and you're breaking stuff, goodness gracious, you've just violated the sovereignty, the territoriality of that country, because you're operating, you're creating physical effects in a country. And we would all agree that one state may not engage in what are called inherently governmental functions in another state. The best example is law enforcement. In Australia, only Australian law enforcement authorities have the right to engage in law enforcement operations. Americans may not do so in Australia unless you give us permission. Okay, why? Because it's sovereign Australian territory. Law enforcement is inherently governmental. And that's true even in cyberspace. If we want to conduct law enforcement like searches into Australian cyber infrastructure, we need to get the authorization of the Australian government. Everyone agrees with that. The problem is, we in the Tallinn Manual group and in the GGE, although there's agreement that sovereignty applies, that it is a rule that can be violated, we weren't quite sure where the line was. We knew you violated sovereignty if you're breaking things or you're hurting people. We knew that. That's self-evident. But what if you're simply manipulating cyber infrastructure in another country? You're making cyber infrastructure do things it wasn't meant to do. Is that a violation of sovereignty? Well, I think it is, but not everyone does. What if you're implanting malware into cyber infrastructure, private or public, in another country? And that malware doesn't quite do anything. It's malware that just waits until you activate it. Have you violated the sovereignty of that country? I don't know. I don't know the answer to that question. So in sovereignty, there's a massive gray area, and we can watch states will seek to act in this gray area because it is to their advantage. Intervention, I mentioned. Intervention into the internal or external affairs of another state. There are two elements to intervention, the prohibition of intervention. One is that the act involved the domaine réservé. I know you're shocked that a Texan speaks so much French. The domaine réservé of another state. Domaine réservé means an area of activity that is reserved to that state alone, that international law doesn't have anything to say. The classic example happens to be elections. In fact, in the book, elections is the example we used, and that preceded the Russian hacks into the United States. So clearly elections. In addition to the domaine réservé, the act must be coercive. In other words, it must make a state do something it would otherwise not do. Oh, this means 5 minutes, or are you waving at me, Matt? If we were in Greece, this would be a real problem. The domaine réservé, the act must be coercive. And so this is very gray. We know that elections is a domaine réservé. We know that maintaining the security of a country is a domaine réservé. But let's take the security example. What about international human rights law? Can you do anything you want to maintain the security of your country? Well, the fact is you can't, because international humanitarian law puts limitations on what you may do, which means it's not part of the domaine réservé, which means other states may intervene or may interfere in that area. So if a country is blocking access to the internet for its people, in other words, if they're blocking freedom of expression, another state can go in and create access for individuals to express themselves, and that's not intervention. So this is a very unclear area. Where does security stop and human rights start? We don't know the answer to that question. The good example, I think, is the example I've already cited. Elections are clearly domaine réservé, but were the Russian operations coercive? Mike Schmitt says yes, and my colleague Lise Vihul says no, they weren't coercive. In fact, goodness gracious, I say they were coercive because it made the process work like the process wasn't supposed to work. She says, no, 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 no. Elections are about knowledge. More knowledge is better. So the more electorate knows, the better. That's not intervention, that's facts. So attribution is another area. When I travel around, this is the question I get asked most often. What about attribution of the acts of a non-state actor, a hacker group, to a state, such that it's as if the state itself had conducted those operations? Well, we know what the law is. The law, it was written by James Crawford, by the way. The law on this is that if a non-state actor, a hacker group, is acting pursuant to the instructions or under the direction or control of a state, then the actions of that non-state group are as if the state did it. We know that. And we know some more facts because of a famous case in the ICJ, the Nicaragua case. We know that that doesn't involve financing. So if you finance a hacker group, you are not responsible for their actions. If you provide malware to a hacker group, you're not responsible for its actions. But if you plan or supervise the operation with the hacker group, you are. That's what we know. But there's lots of gray here. For example, What if you have de facto control of the group? So this is a hacker group. They're conducting operations that I kind of sort of like, and I finance them entirely. I'm not just a source of income, I am the source of income. Don't I have control over the group? We're not so sure. International law is gray in this area. What if the group exists for the sole purpose of achieving my agenda? That's the only reason the group exists. Is that control? Gray area, we're not sure. And then with regard to peacetime law, there's the law of due diligence. I've already explained what that is, but I have to confess to you, although we believe the concept of due diligence applies in cyberspace, not everyone does. It's an international environmental law principle that we have taken and applied to cyberspace, and many people say you can't do that. It only applies to serious adverse consequences that are caused in another state. But what are serious adverse consequences? What's serious to her is not necessarily serious to me. Okay? And that's true with states. And finally, there's debate over whether the obligation to police your territory is just to make bad guys knock it off, or whether you have to take actions as a matter of law to prevent your territory from being used to conduct hostile cyber operations. Do you have a legal obligation to, for example, pass regulations that create cyber hygiene in your country? We don't know that. And finally, last gray areas, the jus ad bellum, which is the law governing the use of force found in the UN Charter. We're not too sure what a use of force is. There's a prohibition on one state using force against another state. Clearly, if you conduct destructive cyber operations, you violated that prohibition. But what if you don't? What if you just hack it into their stock market and change in the numbers? Is that a use of force? And in fact, is that an armed attack such that the other side can now resort to self-defense? I believe if someone attacks the American stock market, that's an armed attack. I believe that. But not everyone does. It's a gray area in which the bad guys can operate. And then finally, I won't go through the details because Matt's going to do 1 minute here in a second. But international humanitarian law also has lots of gray areas. The most important being, can I conduct cyber operations against civilian targets, cyber targets, if I don't kill someone or break something, if I'm just manipulating the processes? This is an unanswered question in humanitarian law. So, I'm here, last two slides, Matt. I'm here to tell you that clarity is what we need. Ambiguity is not good. I will admit that ambiguity creates operational and strategic flexibility. But I'm here to tell you clarity is better. Why? Because clarity enhances deterrence in cyberspace, because it makes clear to the bad guys what the costs are going to be, what the potential cost. It takes away the gray area. It allows for condemnation. Clarity allows you to condemn states for violating international law, and it opens the door to you responding against the bad guys when they act. It also lowers the risk of escalation. An escalatory spiral can happen because we misunderstand the law. So one state conducts a cyber operation that that state believes is lawful. Unfriendly, but lawful. I look at that, I interpret that as unlawful. And as a result, I do one of those countermeasure things. Now when I do the countermeasures, which are only available if the act was in fact unlawful, against the first state goes, what is going on? We didn't break the law, and now you're breaking the law against us. We'll respond in kind. Clarity limits the risk of escalation. And finally, the last thing that's good about clarity is that although it gives you operational and strategic flexibility in your operations, gives the other side operational strategic flexibility as well to operate within the gray zone against you. So what's my prognosis for the future? How do we shrink the gray area? How do we achieve clarity? Don't count on the global community doing so. We've been there, done that. That failed. It's not going to work again. We will not see the global community coming together in the near future to agree on what the law is on cyberspace such that the gray area shrinks. We may see bilateral efforts. Even the Americans and Chinese have an agreement about a particular aspect of cyber operations. We'll see regional efforts will succeed. for example, in the European Union, or for example, among what are known as the Five Eyes states, the United States, Canada, United Kingdom, New Zealand, and I can't think of the other one. Anyways, Australia. What you're going to see as unofficial efforts will have disproportionate, unfortunately, weight. Because when an Australian legal advisor is facing a cyber incident, he or she is going to look at the only thing available. So good or bad, the Tallinn Manual is going to come out on the table. And that's not good, because states and only states make law. But if states are going to forfeit the legal battle space to academics, we'll take it. We need to see more legal capacity building. When I travel around and talk to government advisors, I'm stunned and shocked at the lack of understanding of how international law applies in cyberspace. So we need to build that capacity. It's for a very simple reason. Here in Australia, you probably have a lawyer that dedicates him or herself to cyber activities. But if you go to Chile, I just returned from Chile, if you go there, the person that does cyber in that Ministry of Foreign Affairs has a portfolio that includes 18 other subjects. Cyber is peripheral. So we have to build knowledge, and the Dutch are doing this through something called the Hague process, where they're sending teams around to teach cyber. And finally, and ultimately, it's about states. It's about states, because remember, international law is made by treaty, which requires more than one state, but it's also made by custom. States engage in a practice over time. They do so out of a sense of opinio juris, a sense that they're obligated to engage in that conduct. They expressly say they're obligated to engage in that conduct or refrain. And over time, a critical mass forms, and you have either new law or an agreed upon interpretation of existing law. And I believe that's what's going to happen. Individual states will begin to engage in state practice and opinio juris. And with that, I'll turn it over to my friend Dale Stevens to introduce Vicky.
Thank you.
Thank you.
Thank you very much, Mike, for your presentation. Very, very sobering view about the uncertainty and lack of clarity in this area. Thank goodness in the space field it is an oasis of clarity and certainty, and Millimos is determined to be decisive.
Good luck with that.
Yeah, well, you're going down with the ship, my friend. Okay, my great honour now to introduce our next speaker, who's going to provide a commentary on Mike's presentation. Commodore Vicky McConaughey, RANR, CSC, who sits on our Board of Advisors for Rumley. I have known Vicky for about 25 years. We were both Navy lawyers together, although she was also a supply officer. She had a spectacular career in the ADF, rising to the rank of Commodore and Director General of the Defence Force Legal Service. I followed in her wake, not to Commodore, but in her wake in jobs that she did. And I filled jobs that she had established, and I moved into these areas that she had fixed or established, and I moved into areas where the lawyer's role was very powerful. So thank you for that, Vicky, including working in the late 1990s for then Commodore Scarce in Naval Training Command. Vicky was Director General at a time when the ADF was doing everything. We were involved in Iraq, we were involved in Afghanistan, we were involved in border protection, we had soldiers dying, we had operations that were very, very serious and had major legal implications. Vicky was at the head of all of that in perhaps the most testing time of the ADF and certainly in the ADF legal world. Cyber was making itself known, and space was at least a twinkle in my eye at the time. To that end, she dealt with a lot and navigated us all very successfully through that. She now heads a government department in Attorney General's. She has a great sense of humour. She was Miss Canberra, and she has, for this purpose, the unique background skill of having briefed James Crawford in a matter. So a direct experience with James. With that, Vicky, I'd like to hand over to you. Thank you.
I would say there's a lot in that last conversation that Mike has led us through to think about. And it got me thinking off at some tangents, which, and they're about, in some ways, the domestic law as well. For some time, I now deal in an area where we look at the domestic law, partly in this space. And we're always trying to come to terms with how we can create law around disruptive technologies. And cyber is all about disruptive technologies because it's not something that's a constant, it's something that changes all the time. And when you're trying to create law around technologies that just pop up at you, the law always follows in its wake. And that's where I think international law actually has an advantage. And Mike touched on those advantages, and that's because it's principles-based. And so instead of trying to prohibit every little thing as it pops up and, bat it down, the principles can be applied. At the same time, that principle base can lead to those grey zones. And it got me thinking, those grey zones. And one of the things that got me thinking about is in about 2008, I think I was at a meeting of the lawyers the countries that were in Afghanistan together. And David Bethlehem was there. And David Bethlehem said very sagely at one stage, well, there's international law and there's the secret life of international law. And I think that cyber actually overlays with that secret life of international law, which makes it even harder to determine what exactly is going on. On my morning walk today with my husband, who actually for a while worked in the Defence Space Coordination Office, otherwise known as DISCO, we were chatting about the paper the draft paper I'd seen on some of the things that Mike was covering. And my husband said to me, do you know that the US has just grounded a whole bunch of drones? And these drones have been grounded because they're a Chinese-made drone, and there's been a software update. And apparently this software update causes some concerns to the government, so they've grounded them all. And that's another thing about cyber, is you do have that little bit of code that can sit there, and it can sit there and then at the most critical moment take down a defensive measure or take down something that's going to assist you in operations. So how do you react to that? You could say, well, you've got plenty of time, you can fix the code. But if you've just had to take down something like a whole bunch of drones that you're using in your operations, and that leaves a hole in your capability because you didn't see it coming, where does that leave you? And what sort of measures should you be able to take back? Interestingly, though, when I was getting on the internet this evening to have a look at that story, and I did find the story, I found another counterpart to the same story. And that was that the particular drones, and we actually have one at home, I have to say, which is probably what sparked my husband's interest, have been used by ISIL in the war in Syria, apparently. And there, the Chinese are we don't know it's the Chinese, though. Someone has very helpfully geofenced the drones, which means that they can't operate in certain areas. So while that seems really good because it's happening to people against whom we're operating, it wouldn't be really good if it was us either. And so, as I say, it's good to see that in international law you have that opportunity to apply the principles, because the things that you haven't thought of come up at you out of the blue. And I don't think that there's going to be any change in disruptive technologies. The other thing we tend to talk about domestically in the cyber sphere is this idea of going dark. And I think that's a risk for the law as well, because cyber happens in a space that we can't see, we can't touch, and often we don't know where it has evolved. As in geofencing, it should have occurred to me, but I have to say it's not something that I've thought of every day. As in some of the attacks that may have happened on different essential facilities. When, you know, if part of an electricity grid goes down and someone's just experimenting to see what they might do in an actual wartime operation, what response do you have to that? So I did note with interest the grey zones that had been set out, and I have to say I look forward to reading the Tallinn Manual more fulsomely. And while I think that it's in countries' interest to do, as Mike Schmitt has suggested, and that is to clarify the grey zones, it's never going to be an area where there are, you know, bright lines. There will always be grey zones, and those grey zones will occur because the technologies will change and there'll be a technology that comes up that we haven't foreseen. And so in that light, I should say that I think it's important that we do look at those principles in international law. And where do you justify, for instance, self-defence? And it also had me thinking about the fact that often it's hard to tell where a cyber matter is. I know that the infrastructure for a cloud might be in Singapore, but people from around the world access that cloud. Does that mean that the Singaporeans have an entitlement to take down all the information out of that cloud because there's they have a problem with it and that might affect a country, or because it might allow them to influence another country? I'm not sure. I note that Mike has tended to concentrate on Russians and I would have expected that in many ways because of what has happened with the American elections. But here in Australia, I think we rightly can look more closely to home. And I note that I think it was in about 2014 that Mandiant noted, and that's a particular publication, that 140 companies in the US had been affected by cyber operations out of, I think, the Shanghai Bureau, which was part of the Chinese government espionage infrastructure. And I think the response there from the American government at the end of the day, and I may be incorrectly linking these two things, was to actually lay charges, so to use domestic law rather than international law. But to have 140 companies affected by a state spy network seems to me to go beyond just something that might require a criminal law response. But I think that goes to the fact that people are cautious in this area in how they respond. So, it did make me think there's other things like driverless cars. What if someone puts a bit of code in your driverless cars and then one day when you all go to work, you can't go anywhere? Exactly where does that sit at international law? And I could go on and look at some of the other examples, but I'd like to say that in this area, while we need to try and shrink the grey zone, the risk here is that the grey zone becomes a black hole because we really don't know what technologies are doing. I think in the international sphere in many ways, having listened to Mike, he's been very sage in saying that we need to clarify these principles. And I think the principles will hold us in good stead because to try and prescribe via treaty every individual act will not work at the end of the day because things change too swiftly in the technological area. But Mike, thank you for your presentation. I found that it gave me much to think about, and I look forward to discussing it with you further. Thanks.
So we do have time for a couple of questions, but of course I have to say that being someone who taught law and popular culture, if you're at all interested in that example of the Chinese chips in the drones, there's a fantastic book called Ghost Fleet, which looks at all of these issues in terms of needing to go back to the pre-digital era to get essentially clean technology that might not be susceptible to being hacked. It covers space, it covers drones. It's very cool. With that said, I might ask if Mike could come back up here, and Vicky as well, if that's all right, and ask if anyone has any questions for our guests this evening.
I suppose a lot of the presentation discussed the responsibility of states, but is there much commentary, I suppose, on the status of the non-state actors in this area? And I suppose my thoughts are mainly in areas like Syria, where there's civil war or non-international armed conflict crossed over with international armed conflict. So one aspect is what status they have when they're acting by themselves, and has there been any thought of whether or not there's a threshold where they could perhaps fall into that mercenary context?
So, that's okay, I have a magic device. So yeah, we did address that during a non-international armed conflict. Clearly, non-state actors are governed by international humanitarian law, so it really doesn't matter if you're part of the state or not. The same principles of humanitarian law govern your activities. So if we take the Syrian Electronic Army, there has subject to the prohibitions found in international law as state armed forces, with regard to, don't attack civilians, et cetera, et cetera, et cetera. They're not mercenaries because the concept of mercenaries is a very, very limited concept. There are 5 requirements. We won't go into them here, but it's really, really hard to be a mercenary. And so they are simply non-state actors in the battle space, and so they're governed by international law. The real question with regard to non-state actors isn't with regard to their activities during an armed conflict. It's non-state actors outside the context of an armed conflict, and there the issue of attribution is the critical issue. But the problem with international law and non-state actors, when you have them acting in a situation where their actions are not attributable to states, is that international law isn't really about private entities. It's not about non-state actors. International law is a body of law that governs relations from one state to another state. So let's take sovereignty. Australia can violate the sovereignty of New Zealand, but an Australian whose acts cannot be attributed to Australia cannot do so. Australia can violate the prohibition on the use of force, but a non-state group, a hacker group, doesn't violate the prohibition on the use of force. They violate criminal law. So this is a big void that is not well understood. International law doesn't reach much the activities of non-state actors until you rise to the level of an armed conflict, either non-international or international in character. Does that answer your question?
Rebecca, and then
I talked to you for an hour yesterday and you want more?
It barely scratched the surface, Mike. No. I've got a question which is for both of you. And there was a Constitution Day speech given at the NSA by Benjamin Witz, who is he's a commentator in the US. And what I liked about it, and it melds both of your talks, is that he was sort of speaking about the idea of the bad guy. And it was just at the time where the US had spied on Germany, and he said,
Spied on Germany? I don't know what you're talking about.
And he said, I went to Germany, and he was explaining how it was a tough gig. Everyone laughed at the NSA. And he said, you know what I told them? I told them to grow up. And then he said, and it took a turn at the NSA, he said, and I'm going to say the same to you now. When you speak about China, grow up. We do it, and they do it. And I was thinking about this when you were talking, because if we're not after the red line, and we don't like the grey, what we want is some idea of restraint. But how can we get restraint? So we could imagine in East Timor they're talking about us, saying, the listening devices. Who's bad? Who's good? How do we stop laughing or pointing the finger? And what are we after here?
I'd say it's not about who's bad and who's good. It's about ensuring that the principles restrain people from going down a spiral. I think that was something that Mike talked about. So it's about putting that restraining hand. And I will just tell a brief story. When I was still in the military, I went to a Pacific Command conference, and it's some years ago now, and there was a Chinese lawyer at the Pacific Command conference who gave a presentation. And what was really interesting was at that time, China wasn't talking about law of the sea. It was thinking of itself in coastal terms, and I find it very interesting to see how now it talks about law of the sea, and it uses it as a projection of its power. And I think the same happens, that there is a certain degree towards which law assists people to understand how they can project their power within a reasonable framework. Sometimes they don't stay within the framework, but they become interested in it. And here in the cyber world, I think people will become interested because they're as much interested in not being devastated out of the blue as we are. So it's really about restraint. Anyway, that's my...
Yeah, I mean, I agree with Vicky. I think it's all about, I mean, I don't want to be too realist here, but it's all about cost-benefit analysis. And what you have to do is convince everyone that the cost outweigh the benefits. The problem is that not only between countries, but within countries, what you see depends on where you stand. So if you are working for the armed forces, or if you're working for an intelligence agency, you see opportunity in the gray area, opportunity in what Ben says, the grow up. Ben is the editor, he's a friend, he's the editor at Lawfare. Many of you have heard of Lawfare. So you see opportunity in this grow up realm. But if you work, for example, for the Ministry of Foreign Affairs or the entity that's responsible for safeguarding your cyberspace, that's not what you see. You see cost in those particular activities, the grow-up activities. And so this is the problem. It's difficult, if we want to move forward, as you suggest, it's difficult to get states to agree because they don't assess cost-benefit in the same way. Some states have capabilities, some states don't. Some states are have the capability to be aggressors, and some states only have the capability to be victims. And then within countries themselves, the various entities that are involved in the cyber dialogue assess cost and benefit differently as well. So my big argument is we all need to start thinking in a cost-benefit analysis, and we need to think more holistically. It's not just about what can I do, what does the gray area represent in terms of opportunity, but I need to look across the aisle and see what it represents in terms of cost. But that's a heavy burden. The sovereignty debate in the United States that I suggested is an example of this. By making sovereignty go away, that's good if you want to engage in operations. It's really bad if you're responsible for safeguarding the United States, because now you're limited to, as Vicky said, only domestic law with the 5 PLA officers who were indicted. Does that answer your question, Rebecca? Yeah. Okay.
Thank you, Mike.
Thanks.
And we've got one last question from up the back there. Thanks.
Hi.
Hi there.
I've got a question regarding sovereignty and the breakdown in the recent negotiations. So a few minutes ago you were talking about how Australia can violate New Zealand's sovereignty, but an Australian can't.
Right.
You named 3 countries. You named China, Russia and Cuba as being some of the causes of the breakdown of negotiations. Do you think that might be a response to the allegations emerging surrounding the United States election, and how, given the ambiguity that is natural in the cyber environment, it may be impossible in the moment to pick between an Australian and Australia when it comes to an attack, and whether those states are attempting in trying to prevent countermeasures becoming firm international law, whether they're attempting to protect themselves against a possible attack on them due to their reputations as communist and recently post-communist countries, and whether that might be closer to a look at the West's relationship with countries like that. Because I note you said, and other states. but you only named those 3. And I'm just wondering whether it's a perception issue and whether it's a safeguarding issue for them as states to protect themselves from their own non-state actors starting a war that then they'll have to wear.
Can you repeat the question?
I would be happy to.
No. So why do I think it broke down? I don't think it has anything to do with them protecting non-state actors in their states, because I'm pretty convinced, although everyone in my country isn't convinced, I'm pretty convinced that those operations were either conducted by state entities or clearly attributable to states pursuant to the law of state responsibility. But as to the future, I think what happened is those operations were conducted and they were highly successful. They were highly successful because to some extent they contributed to the intended purpose of the operation, and they got away with it. I mean, now the U.S. government is looking at returning the property that was taken from the Russians. So what does that tell us? It tells us exactly the point you made. The bad guys, the ones that are not committed to the rule of law, have identified the fact that they can operate in the gray zones, and because they are operating against states that are committed to the rule of law, this means that they will do so basically cost-free. And so therefore, I believe that those states are anxious to preserve the gray zone, and therefore they sabotaged the negotiations in the group of governmental experts. I don't think the fact that they are communist or post-communist really has anything to do with it. I think it's the fact that there are some tensions between us and China in your region, and between us and Russia and Europe. I don't think it's a communist. I think they're just the other side of this debate. But you're shaking your head, and I don't want anyone to go away dissatisfied. So despite the timing issue, you get a follow-up question.
My query was more to do with, 2 points. You talk of them as breaking international law and that you have acknowledged that it is a grey zone. It's not yet clear whether they've been breaking the law or not.
Very good point.
And you speak of countries committed to the rule of law, and yet that rule of law does not yet exist. So you can't really have these people who are the good guys and the bad guys obeying and breaking the law at this point in time.
Yeah, but wait a minute. So that's a very good point. Are you a lawyer?
Law student?
Yep, you'll be good. Dean, did you get her name? This is a very good point, but I want to make crystal clear about gray zones. Gray zones are areas of the law that are unsettled. It doesn't mean they're areas that are void of law. They are not lacuna, okay, if you're a law student. They're not lacuna. It's that Rebecca and I can't exactly agree on where the line is. I believe with all my legal heart and soul that those operations violated both the prohibition on violating sovereignty and the prohibition on intervention in the internal affairs of another state. So when I say gray zone, I want the audience to understand. Gray zones are not the absence of international law. Gray zones are areas of international law where there is disagreement as to where the line lies. But in virtually every gray zone we talked about in the Tallinn Manual, we voted. So we actually said, so there were people that said A and there were people that said B. It was every once in a while we said, we don't know what the law is. It's just too vague. But usually we all had an opinion on where the law was. We just didn't agree on where that line was. Does that make sense? So when they conduct those operations, I'm quite certain that the Russians understood that they were violating international law. The problem, or that there was a high likelihood that they were violating international law, but they knew they could get away with it. Because the West, the United States, Australia, other countries are obsessed with international law, and so therefore they will perceive that incident from an international law context, and there will be arguments over it. But no, I think they look for those areas and they operate in those areas. Are you more satisfied now?
Slightly.
Okay,
Thank you.
well,
Satisfied enough to let the dean talk?
Maybe. Now, like every single person in this room, I am more frightened of Matthew Stubbs than anyone else, and I think I'm seriously running the risk of getting one of those rude hand gestures from him. So I am now going to hand over to Dale to do the vote of thanks.
Thank you very much, Melissa. So it is my great honour and privilege to lead the vote of thanks. But before I do that, I made the comment yesterday, for those of you who are in my international law class, that space was actually going to be, current space law was going to be something for your generation, less mine. You'll probably get into space, I probably won't. How sad is that? But, yeah, very sad. But this is also an area, I think, where your legal skills that you're developing through this law school are going to be tested, and you're going to be taking your place in trying to shape this law to minimise this grey zone, find those red lines, and to contribute towards progress, however we might measure that. And so to that end, it's pretty exciting. It was a lot easier when we joined the Navy, and it was just blowing up stuff and kinetic operations. It's much more complicated now, and I guess that's the challenge for all of you. So with that, I would like to present these two gifts. Mike said, can I take it home? We did have, as I said, the Ferrari outside. We've had to turn that back. But you get a very nice book.
Thanks, Dale. Thanks,
Mike.
buddy.
Thank you.
Thanks.
So with that, it's closed. Thank you. Thank you.
Mike Schmitt. Hi.
Lisa, we met
Hi,
at
Lisa.
the
Where?
SSI launch.
Where?
The SSI launch,
The SSI launch.
Space Security Index launch in the Millimos Welcome
Maybe.
at the Wine Centre. Anyway,
Yeah, okay.
as a Georgian, thank you very much.
Oh, you're Georgian.
Incredibly inspiring.
Oh, I've never been to Georgia.
No, it's funny because I think in that exact period is when my family was meant to come over and visit. There were
Ah.
complications because they couldn't access their funds.
So you're Georgian. Can you do incredible toasts?
I'm all about it. You don't leave the house, you stay in the house. You're the designated